And for the third respondents, Jackson Kafuzi, the Deputy Attorney General, the pawn affidavit. Representations were as presented by the Attorney General this morning. Both parties, all the parties submitted orally before this court, citing numerous Kihika, Director of Legal Affairs of the National Resistance Movement. For the second respondent, Byabakama Mugenyi Justice, the pawned affidavit in reply, rebutting the applicant's assertions. And for the third respondent, Jackson Kafuzi, the Deputy Attorney General, the pawned affidavit. Representations were as presented by the Attorney General this morning. Both parties, all the parties submitted orally before this court, citing numerous Kihika, Director of Legal Affairs of the National Resistance Movement. For the second respondent, Byabakama Mugenyi Justice, the pawned affidavit in reply, rebutting the applicant's assertions. And for the third respondent, Jackson Kafuzi, the Deputy Attorney General, the pawned affidavit. Representations were as presented by the Attorney General this morning. Both parties, all the parties submitted orally before this court, citing numerous Kihika, Director of Legal Affairs of the National Resistance Movement. For the second respondent, Byabakama Mugenyi Justice, the pawned affidavit in reply, rebutting the applicant's assertions. And for the third respondent, Jackson Kafuzi, the Deputy Attorney General, the pawned affidavit. Representations were as presented by the Attorney General this morning. Both parties, all the parties submitted.
The basis of the notice of motion giving birth to this application was that Section 98 and 100 of the Civil was Section 98 and 100 of the Civil Procedure Act, Rules 15 and 17 of the Presidential Election Petitions Rules 2001, and Rule 2, Sub-Rule 2 of the Supreme Court Rules. Section 98 of the Civil Procedure Act saves the inherent powers of court to make orders, while Section 100 of the Civil Procedure Act deals with the general power of courts to amend defects or errors in proceedings. They were irrelevant to this application. The same applies to Rule 2, Sub-Rule 2 of the Supreme Court Rules, which governs appeals from the Court of Appeal and the Constitutional Court as per Sub-Rule 1 of the said rule. Rule 15 of the Presidential Election Petitions Rules is equally irrelevant on account of the existence of a specific rule on extension of time, that is Rule 17 of the Presidential Election Petitions Rules, which reads, enlargement or abridgment of time. The court may, of its own motion or on oral application by any party to the proceedings, upon such terms as the justice of the case may require, enlarge or abridge the time appointed by the rules for doing any act if, and here is the emphasis, in the opinion of the court, there exist such special circumstances as make it expedient to do so, except that when considering enlarging time, the court shall take into account the provisions of subsection 3 of section 59 of the Act. We have not laid our hands on any jurisprudence from this court interpreting the above rule. It is clear, however, from the plain language of Rule 17 that it confers a discretion on the court to extend time for doing any act under the rules. The rules do not provide a blank check for extension of time. Like any other judicial discretion, however, it must be exercised judiciously, taking into account the circumstances of the case and in accordance with reason and justice. Therefore, it behoves the party asking for extension of time to demonstrate to the satisfaction of the court that special circumstances exist to make it expedient for court to do so. Arising from the above, the issue of determination by this court was whether the applicant had established that special circumstances existed to warrant the extension of time for filing additional evidence, given the 45 days prescribed under Section 59, subsection 3 of the Presidential Elections Act for determining the petition. We considered the application, the evidence adduced, the submissions of counsel, the authorities relied on, as well as the law. We found the answer to the above issue in the negative for the following reasons. First, Article 104 of the Constitution and Section 59, subsection 3 of the Presidential Elections Act give the time frame for presidential election petition as 45 days from the date of filing. The court has no power to extend the same. Pursuant to that, the court held a scheduling conference on the 11th of February 2021 and gave parties very clear timelines within which to file affidavits in the petition. Court went further to instruct the registry to reject any documents that would be filed out of time. The applicant's counsel never complained about the timelines. If anything, he undertook to file 50 affidavits that very day. Secondly, according to Black's Law Dictionary, 9th edition, at page 1270, pleading is defined as a formal document in which a party to a legal proceeding, especially a civil lawsuit, sets forth or responds to allegations, claims, denials, or defenses. In a federal civil procedure, the main pleadings are the plaintiff's complaint and the defendant's answer. In the instant case, the pleadings included the petition and the answers thereto. Rule 5 of the Presidential Election Petitions Rules, 2001, provides that the petition shall be filed at the office of the registrar within 15 days after the declaration of results. Rule 8 of the Presidential Election Petitions Rules, 2001, provides that the respondent who wishes to oppose the petition shall, within 3 days after service of the petition on him or her, file an answer to the petition. Unless the respondent requires further and better particulars, this would technically mark the end of the pleadings. Thereafter, the court shall fix the petition for trial within 5 days. Rule 14 of the Presidential Election Petitions Rules 2001 provides that evidence at the trial shall be by way of affidavit. Black's Law Dictionary at page 635 defines evidence as something including testimony, documents, intangible objects that tend to prove or disprove the existence of an alleged fact. An affidavit is therefore not technically a pleading, it is evidence. The petition was filed on the 1st of February 2021, and then filing of pleadings was closed on the 6th of February with the filing of the answer by the first respondent. What remained was the filing of affidavit evidence in support of the petition. The issue at hand, therefore, arose out of filing of affidavits, not pleadings. The pleadings were filed within the prescribed time, and there were no issues with them. The allegation in ground 2 of the application that pleadings were still going on is therefore incorrect. Thirdly, court found that the reasons advanced by the applicant as a basis for the inability to file his evidence from the 1st to the 14th of February were not plausible. He deponed in his supporting affidavit that his home was surrounded by security personnel from the 15th to the 25th January 2021, when they withdrew therefrom pursuant to a court order dated 24th January 2021. He deponed also that in the short period of 5 days remaining to file the petition, his lawyers started conducting research and gathering evidence for the intended petition, which they managed to file on the 1st of February 2021. It was his evidence that in the meantime, he and others continued with further preparation and analysis of evidence from all corners of the country, and that he and his party structures obtained more evidence to help in the particularization and support of the grounds pleaded in the petition. He averred that his lawyers advised him that the newly established evidence could only be introduced by way of an amended petition, and that on Thursday, the 4th of February 2021, he paid the prescribed court fees for purposes of filing the amended petition, but that the registrar declined to receive the same and advised him to file a formal application. It is the evidence of the applicant that he proceeded to file an application for amendment, which the court heard and summarily disallowed on the 9th of February 2021 on the ground that the further and better particulars and information sought to be introduced therein could be sufficiently catered for by way of additional evidence. The applicant averred also that during the pre-hearing conference session on 11th February 2021, the court set timelines for filing additional affidavits, and he was supposed to file his additional affidavit by the 14th of February 2021. He deponed that his belief was that being an inquiry into the election process, which had been conducted over a long period of time, the court would permit him to produce evidence for a substantial duration of the trial, as was the case in previous petitions. He deponed further that contrary to his belief, the court granted him only 3 days, and he worked with his lawyers round the clock, day and night, so as to file additional affidavits, including taking testimonies from across the country, with some witnesses' evidence being procured from prisons across the country where some of his members are political prisoners. the applicant concluded that despite all odds, they managed to gather over 200 affidavits across the country. The evidence above lacks credibility. Whilst it is demonstrated that the applicant's movement was curtailed by security officers who surrounded his home in Magere after the elections of the 14th January 2021, it is untrue that the applicant was prevented from gathering evidence because he was able to instruct his lawyers, who successfully pursued an application in the High Court on his behalf and obtained an order removing the restrictions imposed on his movement by security officers. Similarly, he could have, if he wished, instructed his said lawyers to collect affidavits in support of his petition, since he did not have to do so personally. In addition, the applicant's affidavit evidence was not convincing. For instance, though he averred that the delay was partly because some of his witnesses were in prison and attached an index of his intended witnesses to the affidavit, he did not highlight or name those who were actually in prison. Court could therefore not discern who was in prison and who was not. Further, there is no cogent reason advanced by the applicant for failure to file in court those affidavits which he purportedly started collecting, according to his affidavit, soon after filing his petition on the 1st of February 2021. It is on record that court started a scheduling conference on the 11th of February 2021. On that day, counsel for the applicant, in his address to court, stated as follows: "We did indicate to counsel that we would be filing about 50 affidavits within the course of today, and all conditions allowing, we would be filing another 50 if you permit." Counsel for the applicant thereafter sought an adjournment to another convenient date when he undertook he would be more organized and prepared. It is on record also that court granted the applicant an additional period up to Sunday, the 14th of February 2021, to file the additional evidence by 5 p.m. that day. Similarly, the respondents were directed to file theirs by Saturday, the 20th February 2021. The applicant was then directed to file his rejoinder by 23rd February 2021. Further, and in a bid to ease and ensure effective service, court directed the parties to designate representatives and avoid them desks at the court premises for that purpose. Court thereafter adjourned the petition to the 24th of February 2021 for conclusion of the scheduling conference and further hearing. We noted that the applicant's counsel never complained that they had any difficulty in meeting the above timeline. We also noted that court had given the applicant 3 more days to gather evidence after he had already had 10 days from the date of filing the petition. On the other hand, the respondents had only 3 days to answer the petition and were added only 6 days to reply to the applicant's evidence. The record indicates that counsel for the applicant never filed a single affidavit pursuant to his undertaking of the 11th February 2021 or at all until the last minute on Sunday, 14th February at 5 p.m. According to the evidence of the respondents' witnesses in reply, corroborated by that of the registrar, on 14th February 2021 at exactly 4:30 p.m., 2 of the applicant's lawyers arrived at the Supreme Court with 7 copies of affidavits bound as Volume 2, which contained 50 affidavits and 3 separate affidavits in spiral binding. After consulting the Chief Justice, the time was extended to 6 p.m. to enable the applicant's counsel to deliver the remaining 13 copies of Volume 2. Failure to do so in time, they were informed they would be allowed to file them the next day on Monday, 15th February 2021 at 8 a.m. The registrar waited until 7 p.m. that day, but the applicant's counsel never brought the remaining copies of the said affidavits. This fact was acknowledged by the applicant's counsel in his letter dated 14th February 2021, where he stated that on the said date, we were at court by 5 p.m. with the said affidavits, only that some volumes, particularly volumes 3, 4, 5, and 6, got to court late after the court premises had been closed. On Monday, the 15th February 2021, instead of filing the remaining 13 copies of Volume 2 as expected, the applicant's counsel also brought Volumes 3, 4, 5, and 6, which they tried to file in the registry without leave of court. The registry received the remaining 13 copies of Volume 2, but rightly rejected the rest of the affidavits. According to the record, counsel for the applicant did not file the instant application until Wednesday, 17th February 2021 at 5 p.m. in the evening. It is therefore not true that the application was filed without delay. The court found that if it was indeed true that the applicant had difficulties in assembling his affidavits as alleged, he should have applied for extension of time at the earliest opportunity after the registrar had rejected them, or at least by Tuesday, 16th February 2021, because all parties were fully aware that the registry remained open over weekends and public holidays throughout that period. The excuse that he could not file the application on Tuesday, 16th February 2021 because it was a public holiday is thus untenable. Further, Rule 13 of the Supreme Court rules does not apply to election petitions, since Rule 2, Sub-Rule 1 of the rules clearly limits the scope of the application of the rules to appeals from the Court of Appeal and the Constitutional Court. Based on the foregoing, court found that the applicant was guilty of dilatory conduct. In our judgment, granting the applicant's application would prejudice the respondents, who would have only 6 days to answer allegations contained in over 200 affidavits from witnesses from all over the country. Justice must be for both parties. In the case of Raila Odinga and 5 others versus Independent Electoral and Boundaries Commission and 3 others, the Supreme Court of Kenya stated, the period for the filing, prosecution, and determination of a presidential election is only 14 days from the time the results are declared. This is a very tight, short, and limited period. The background to the setting of the strict timelines must be known to most Kenyans. There was a purpose to this, and the intention of the people of Kenya and of Parliament must be respected. The parties have a duty to ensure they comply with their respective timelines, and the court must adhere to its own. There must be a fair and level playing field so that no party or the court loses the time that he, she, it is entitled to, and no extra burden should be imposed on any party or the court as a result of omissions or inadvertences which were foreseeable or could have been avoided. The other issue the court must consider when exercising its discretion to allow a further affidavit is the nature, context, and extent of the new material intended to be produced and relied upon. If it is small or limited so that the other party is able to respond to it, then the court ought to be considerate, taking into account all aspects of the matter. However, if the new material is so substantial, involving not only a further affidavit, but massive additional evidence, so as to make it difficult or impossible for the other party to respond effectively, the court must act with abundant caution and care in the exercise of its discretion to grant leave for the filing of further affidavits and or admission of additional evidence. We hold that if we allow the 7 affidavits to remain on record, the same will be prejudicial to the respondents. This will amount to a miscarriage of justice, and we cannot allow it in the circumstances. In that case, the applicants had applied for extension of time to file 7 additional affidavits. The court disallowed the application for a reason similar to what is before us. We found that authority persuasive and applied it to the instant application, since we were dealing with 200 additional affidavits instead of only 7 as was in that case. Lastly, and most fundamentally, we found that granting the extension would negatively impact on the timelines issued by court, in that it would take away 6 out of the 11 days and would leave court with barely 5 days to internalize, evaluate the evidence, and give a reasoned judgment within the 45 days prescribed by the law. As a result of the foregoing reasons, we declined the prayer to exercise the court's discretion in favor of the applicant by a majority of 8 to 1, and accordingly dismissed the application with cause in the cause.
Thank you, my lord. We will have the last ruling, which is a brief one. Can you call the last ruling? It will be delivered by my brother, Lord Justice Ezekiel Mwanguzi. Call it out.
This is petition number 5 of 2021, arising out of presidential petition number 1 of 2021. Shall be sent tomorrow by the applicant stock petitioner, Pastor Joel Museveni to Habura Kaguta, the Electoral Commission, and the Attorney General for the respondent.
My lord, we'll have to bring the microphone quite close to you.
I think it's on now. Thank you, my lord.
Yeah.
These are the reasons for declining that application. Sorry, for granting the application for withdrawal of the petition. On 5th March 2021, by unanimous decision, the court granted the applicant petitioner leave to withdraw presidential election petition number 1 of 2021. The reasons for the decision were reserved to be given at a later date. The issue of costs was not determined. We now give our reasons for the decision to grant leave to withdraw the petition and resolve the issue of costs. We set out the background of the petition, and specifically we state that 11 candidates contested the election, and we indicate the results as declared by the Electoral Commission. For each of the 11 candidates, showing the exact score of votes and the percentages. Yoweri Museveni Tuhabura Kaguta, the first respondent, having obtained more than 50% of the valid cast votes, was declared winner of the elections. Then we indicate the applicant having filed the application to withdraw the orders, 6 of them, which he sought. We also indicate the answers to that application from the first, second, and third respondents. Then we also indicate that we made a summary ruling in which by unanimous verdict we dismissed the application to amend. Is this the one I'm reading? Well, we're indicating that we have dismissed the other one. The ruling is quite long because it also shows the submissions of both parties, the authorities they relied on, and the law. Then we deal with the way we consider the application in court here. We have had the benefit of considering the pleadings and the submissions of counsel for all parties. Needless to say, this was an application for leave to withdraw a presidential election petition. The enabling law is provided for under Section 61 of the Presidential Elections Act and Rule 20 of the Presidential Election Petitions Rules. We reproduce Section 61 of the Act and Rule 20, Sub-Rule 3. Then we say the aforesaid laws can be summarized as follows. 1, the court retains the discretion to permit or grant leave to a petitioner to withdraw the petition. 2, the applicant and his or her advocate must state in their affidavits that no agreement or terms of any kind has been made or undertaking made in relation to the petition. The petitioner and his advocate must respond to the fact that the decision to withdraw the petition has not been influenced by a corrupt motive. 3, if any lawful agreement has in fact been made, the terms of the said agreement should be stated in the affidavit. 4, notice of the application for leave to withdraw the petition has been made on the court on the court notice board and in the Gazette. The record shows clearly that the applicant complied with the statutory requirements imposed on him in respect of the procedure for filing an application for leave to withdraw the petition. Indeed, he fulfilled a crucial part of the requirements by swearing an affidavit to the effect that the application for leave to withdraw has not been informed by a corrupt motive in paragraph 20 of his affidavit. In support, on paragraph 5 of his advocate Sekaja Ukasha's affidavit, where he states, and we reproduce his statement and that one of Sekaja in paragraph 5. This fact is considered true by all the respondents. We refer to the paragraph 34 of Oscar Chika's affidavit, paragraph 8 of Stephen Tashobia's affidavit, and paragraph 25 of Jackson Kafuzi's affidavit. Notice of the application for leave to withdraw the petition was made by the registrar on the notice board of the court and in the Gazette as required under Rule 20, Sub-Rule 5, Paragraph B of the Presidential Election Petition Rules. Therefore, the application for leave to withdraw the petition, having met all the conditions and procedures required by law, and the respondents having no objection to the application for leave was granted, and the petition was accordingly withdrawn. The court having granted the petitioner leave to withdraw the petition, what remains is for the court to determine the issues of costs and whether court should declare the winner or not. Section 59, subsection 4 of the Presidential Elections Act provides as follows. Where no petition is filed within the time prescribed under the subsection 2, or where a petition having been filed is withdrawn by the person who filed it, or is dismissed by the Supreme Court, the candidate declared elected shall conclusively be taken to have been duly elected as president. And subsection 5, on the other hand, provides as follows. After due inquiry under subsection 3, the Supreme Court may A. dismiss the petition, B. declare which candidate was validly elected, or C. annul the election. It is clear that subsection 5 deals with a situation where an election petition is heard to its logical conclusion. Thereafter, one of the options available to the court is expressly provided for in paragraph B to declare which candidate was validly elected. In the instant case, subsection 4 is the applicable provision. It provides inter alia, open quote, the candidate declared elected shall conclusively be taken to have been duly elected as president, close quote. It goes without saying that without a valid and legal challenge to the candidate earlier declared by the Electoral Commission as the winner of the presidential elections stands unchallenged and is taken to be duly elected president. This fact stands whether or not the Supreme Court declares so or remains silent. It's a fait accompli and does not depend on declaration by court. Does that therefore mean that court cannot declare the candidate as the one validly elected? Or can court, following a specific prayer by the respondents or any other party, go ahead and declare the candidate as the one validly elected? For sure, there is no legal impediment against such a pronouncement. However, it would be superfluous to do so. This is because subsection 4 already provides that where a petition is withdrawn, the candidate declared elected shall conclusively be taken to have been duly elected as president. In conclusion, court can safely say that in accordance with section 59 subsection 4 of the Presidential Elections Act, the petition against the declared candidate Yoweri Museveni Tibuhaburwa Kaguta having been withdrawn, he is taken to have been duly elected as president. On costs, section 61 subsection 4 of the Presidential Elections Act provides, open quote, if a petition is withdrawn, the petitioner shall be liable to pay the costs of the respondent, close quote. And Rule 20, Sub-Rule 1 to 7 of the rules reiterates this position. The question to be determined is, are the aforementioned provisions mandatory or directory? To answer this question would require a review of previous decisions of this court in which the interpretation of the word shall has been dealt with. In the case of Sitenda Sebalu versus Sam Kenjuba and the Electoral Commission, election petition number 26 of 2007, this court discussed section 62 of the Parliamentary Elections Act, where the word shall
in previous petitions. He deponed further that contrary
of an amended petition. Going by this averment, it is not in doubt that the applicant is introducing new grounds which in itself is contrary to the general principles governing amendment of pleadings. In arriving at this finding, we are also persuaded by the decision is Espaneto versus Uganda Commercial Bank, where court observed that a proposed amendment which introduces a new cause of action after the expiry of a period of limitation must be rejected. A similar position was held by the court in Auto Garage and others versus Motocove. Matters are not made any better given the position that the respondents had already filed their respective answers to the petition. And if this court were to allow the amendment, it would necessitate the respondents to amend their respective answers to the petition, which procedural aspects are not provided for under the law for the determination of a presidential petition we have alluded to above. Regarding the argument that the applicant, through his proposed amendment, was introducing new grounds pertaining to non-compliance with the laws and commission of electoral offenses, we find that these were already pleaded in the earlier petition filed in this court, and reproducing them in the proposed amendment would be superfluous. There is no restraint to the applicant to produce relevant evidence at the trial to prove the election offenses he alleges. As to whether the amendment was filed out of the timelines for filing a presidential petition, it was a respondent's argument that the proposed amendment introduces new grounds and causes of action which are brought outside the permitted time by the law. According to the respondents, the timeline set for doing specific acts in the trial of a presidential petition are well stipulated under the law, and that the applicant cannot be seen to commence a new cause of action outside the law. We have already found that the proposed amendment by the applicant introduces new causes of action, which, if this court were to allow, would be outside the set constitutional timelines. In addressing this question, we are also persuaded by a decision of Rao and others, where it was observed that the general rule is well settled that the statutory requirements of election law must be strictly observed, and that an election contest is not an action at law or a suit in equity, but is purely a statutory proceeding unknown to the common law, and that the court possesses no common law power. It is also well settled that it is a sound principle of natural justice that the success of a candidate who has won at an election should not be lightly interfered with, and any petition seeking such interference must strictly conform to the requirements of the law. We indeed we find that Article 104 makes it mandatory for an aggrieved candidate to file a petition within 15 days after the declaration of results. The applicant complied with that constitutional requirement when he lodged his petition in the registry of this court on the 1st of February. Like we have indicated before, the applicant's attempt to amend his pleadings, wherein he introduces new causes of action, would tantamount to filing his petition outside the time allowed by the law. It was submitted on behalf of the applicant that this is not an application for extension of time. We agree, but must add that this court has no authority to extend the time within which a party would file a petition challenge the results of the petition. This court is in agreement with Madan Agrawal versus Rajiv Gandhi, where it observed that there is a long line of authority for proposition that there can be no amendment to a petition after expiration of time limit. He outlines a number of decisions where the court indicated that an amendment would not be allowed where there was a rigid time limit of time for the presentation of the petition. To allow otherwise would have a practical effect of extending the time for filing the petition. We are very persuaded by the above decision in as far as the limitation imposed on this court by the Constitution to be filed within the time frame. And we rule that the court has no powers to extend that timeline. It was further submitted that the applicant that he was incarcerated by security forces who restricted his movement when his home was surrounded. We noted that although the applicant was incarcerated and a trial, he did have time and space to consult his lawyers, and he confirmed before court that he did have time. So that is not a reason to grant him extension to amend his petition. The applicant referred court to the decision of Mama Babazi versus Yoweri Kaguta Museveni, where the court allowed an amendment to the petition to be made. We have had the benefit of reading the decision of court in a Mama Babazi case. The application was brought under Section 100 of the Civil Procedure Act and Article 126 of the Constitution. We have already indicated before that the Civil Procedure Act and rules do not apply when it comes to the amendment of presidential election petition. We find that this court is restricted by constitutional timelines to conclude the petition within a specific time, which if relaxed, the court will not be in a position to deliver its decision within the time required by the law. While we recognize that the doctrine of precedent is very vital for certainty of laws, we are also aware that the role of the Supreme Court as an apex court in this country is to state the correct position of the law to guide the lower courts. And we are fortified by Article 132(4) of the Constitution. That article provides as follows. The Supreme Court may, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so, and all other courts shall be bound to follow the decisions of the Supreme Court on question of law. Arising from the above provision, this court has on many occasions departed from its previous decisions for the good of law. A case in point is Rwabugande versus Uganda, Supreme Court Civil Criminal Appeal number 25 of 2014, which is a notorious judgment within this jurisdiction. In view of our analysis above, we conclude that the correct position of the law is that a presidential election petition is not subject to amendment like ordinary suits. We accordingly decline to allow the application. Overall, we find that this application is misconceived and has no merit. Consequently, the same is disallowed as it seeks to introduce new grounds, causes of action not canvassed in the original petition, which is against the general principles governing amendment of pleadings. The proposed amendment also reproduces electoral offenses which we found were already pleaded in the petition, and we categorically stated that the petitioner did not require any amendment, but only evidence in support of those allegations he had made in the pleading. For the above reasons, this application must fail, and we have dismissed it with no orders as to cost.
Thank you, my lord. Read out, call out the next.
Mrs. Application number Application number 4 of 2021, arising out of Presidential Election Petition number 1 of 2021, Kyagulanyi Sentamu Robert, applicant stroke petitioner, versus Yoweri Museveni to Habura Kaguta, the Electoral Commission, the Attorney General, for the respondents. Quorum is as before.
The ruling of court will be delivered by Lord Justice Paul Mugambo.
This is an application for extension of time to file additional affidavits in presidential election petition number 1 of 2021. I shall go through the basic aspects of the ruling. Three orders were sought. One, that the time granted to the applicant for filing additional evidence in support of the petition be enlarged by 1 extra day to enable him file and serve all his compiled affidavits. Two, that the respondents be given some extra days to file responses. The third was for costs of the application to be provided for. 7 grounds were given for the application. The first was that the applicant filed the presidential petition on the 1st February 2021 and served the respondents. The second was that filing of pleadings was still ongoing. The third was that the filing of additional affidavits in the petition was necessary to enable the court to effectively inquire into and determine all the questions involved in the petition. The fourth was that there were prevailing special circumstances that warranted the grant of the application. Fifth was that the applicant brought the application without any delay. Sixth, that the respondents shall not be prejudiced by the extra time being granted to the petitioner to file and serve additional evidence in the petition. The seventh was that it is in the interest of justice, equity, and fairness that the applicant be granted extra time to file and serve the additional evidence in the petition. There was a background to the application. General elections were held in Uganda on the 14th of January 2021. The applicant and the first respondent were among the 11 candidates who participated in the said election. On the 16th of January 2021, the second respondent declared the first respondent as the validly elected President of the Republic of Uganda. The applicant was aggrieved by the result and filed presidential election petition number 1 of 2021 on the 1st of February 2021, challenging the validity of the election of the first respondent. In the petition, he alleged that the election was not conducted in accordance with the provisions of the relevant electoral laws and that the non-compliance affected the result in a substantial manner. The appellant alleged also that the election was marred with electoral offenses such as violence and intimidation that were committed by the first respondent personally or by his agents with his knowledge, consent, or approval. He prayed inter alia that the election of the first respondent be annulled and set aside and fresh elections be conducted in accordance with the law. Upon service of the petition on them, the respondents filed their respective answers opposing the petition. Thereafter, on the 11th of February 2021, court commenced the hearing of the petition with a scheduling conference during which court issued guidelines or roadmap on the way forward. The court in particular issued the following specific directives regarding the filing of affidavits by the parties, and the parties agreed to adhere by them. Those were: 1. The applicant was directed to file all affidavits by Sunday, the 14th of February 2021. Second, the respondents were directed to file the affidavits in reply by Saturday, 20th February 2021. Third, thereafter, the applicant was directed to file any affidavits in rejoinder by Tuesday, the 23rd of February 2021. An arrangement was put in place for instantaneous service to the opposite parties. The applicant filed a total of 53 affidavits on the 14th February 2021. Apparently, the applicant attempted to file more affidavits on the 15th of February 2021, but the registrar rejected them because he was out of time. This prompted the applicant to lodge the instant application on Wednesday, the 17th February 2021 for extension of time to file the said affidavits. As indicated earlier, court dismissed that application, dismissed it, and reserved the detailed reasons. I shall not delve into the submissions. The basis of the notice of motion giving birth to this application was that Section 98 and 100 of the Civil was Section 98 and 100 of the Civil Procedure Act, Rules 15 and 17 of the Presidential Election Petitions Rules 2001, and Rule 2, Sub-Rule 2 of the Supreme Court Rules. Section 98 of the Civil Procedure Act saves the inherent powers of court to make orders, while Section 100 of the Civil Procedure Act deals with the general power of courts to amend defects or errors in proceedings. They were irrelevant to this application. The same applies to Rule 2, Sub-Rule 2 of the Supreme Court Rules, which governs appeals from the Court of Appeal and the Constitutional Court as per Sub-Rule 1 of the said rule. Rule 15 of the Presidential Election Petitions Rules is equally irrelevant on account of the existence of a specific rule on extension of time, that is Rule 17 of the Presidential Election Petitions Rules, which reads, enlargement or abridgment of time. The court may, of its own motion or on oral application by any party to the proceedings, upon such terms as the justice of the case may require, enlarge or abridge the time appointed by the rules for doing any act if, and here is the emphasis, in the opinion of the court, there exist such special circumstances as make it expedient to do so, except that when considering enlarging time, the court shall take into account the provisions of subsection 3 of section 59 of the Act. We have not laid our hands on any jurisprudence from this court interpreting the above rule. It is clear, however, from the plain language of Rule 17 that it confers a discretion on the court to extend time for doing any act under the rules. The rules do not provide a blank check for extension of time. Like any other judicial discretion, however, it must be exercised judiciously, taking into account the circumstances of the case and in accordance with reason and justice. Therefore, it behoves the party asking for extension of time to demonstrate to the satisfaction of the court that special circumstances exist to make it expedient for court to do so. Arising from the above, the issue of determination by this court was whether the applicant had established